Welcome to Literary and Jury Charge Practice. Let's get started with this jury charge. It is a criminal jury charge and special circumstances. Criminal with special circumstances. Ready? Here we go. Now you have been instructed also that there are certain special circumstances which have been alleged. These circumstances are set forth in the instruction with respect to special circumstances. There is a special allegation which you were instructed on, and that is that the defendant personally used a firearm in the commission of these offenses, and there is a verdict form with respect to the special circumstances. If you will look at your verdicts, you will see the following special allegations alleged. They are special allegations in this case that the murder was committed by the defendant while the defendant was engaged in the commission of a crime or was engaged in immediate flight after having committed the crime of robbery in violation of the penal code. If you find that to be true, that the murder was committed while the defendant was engaged in the commission of robbery or was engaged in the immediate flight after having committed the crime of robbery, that is a special circumstance. That is a special circumstance that the murder was committed while the defendant was engaged in the commission of a crime or was engaged in immediate flight after having committed the crime of burglary in violation of Penal Code Section 190. Those are two special circumstances or special allegations that you are to find true or not true, and there is a special verdict for those findings. There is a special verdict for your finding of whether the defendant used a firearm in the commission of the crimes. Those are special allegations that were charged against the defendant along with the charge of murder and the charge of robbery. Excuse me. All right, a little more jury charge practice. This is one that we had started. And we're actually almost to the end, and it is called damages. The subject of this jury charge is damages. Ready? In arriving at your verdict, you must not make a compromise between the question of liability and the amount of damages given, if any. In the examination of prospective jurors for service in the trial of this case, some questions were asked by counsel to learn whether any juror had an interest in a casualty insurance company. This was done for the sole purpose of discovering if any of you had a biased viewpoint. You are reminded that no insurance company is a party to this action, and that whether either party is insured has no bearing whatsoever on any issue. That it is your duty to decide. The allegations contained in the complaint as to the amount of damage plaintiff claims to have suffered are but claims and are not evidence and are not to be considered by you in arriving at your verdict or in fixing the amount in the event your verdict is for the plaintiff. If you find from the evidence that the plaintiff is entitled to a verdict, you must not, in ascertaining the amount of that verdict, resort to the pooling plan or scheme which has sometimes been adopted by juries for fixing such amount. That plan or scheme is where each juror writes the amount to which he considers the plaintiff is entitled, and the amounts so written are added together, and the total is divided by 12. This is a scheme of chance, and no element of chance is permitted to enter into your deliberations. To reach a verdict in this case, as most of you know, it is not necessary for all 12 jurors to agree. Under the law, the concurrence of 9 jurors is necessary. Whenever 9 of your number have agreed upon a verdict, it should be signed by your foreman and returned into court. Now let's try some literary material. And this is one we had started called Not Ever Lacking a Captioner. Here we go. The worship services we caption are every Sunday morning at 9:30 a.m. And yes, everything from beginning to end is captioned, including the songs. The choir director emails the sheet music straight to Diane now, and she covers most of the worship services these days. Diane emails the material to me when I'm covering for her. Sheet music and a cover sheet are included, as well as an outline of the order in which the songs will be sung. This incorporates the title of the sermon for the day, as well as the Bible verse that will be referenced. We then research the Bible verse for prep. Sunday morning begins by the captioner calling the people in the control room before the church service starts, and then sending a test of the captioning to ensure the captioner is connected to the church modem. The captioner also makes sure they can hear the service through the audio line. When Sharon was asked if there have been any obstacles that she had to face along the way, she answered, "Now that my dictionary is built up, the obstacle I encounter most frequently relates to the sheet music that is sent to us. Sometimes it encompasses 45 pages or more. Of course, we don't need the entire choir version, only the lyrics are necessary for our part. To get around this, I scroll through all the pages and print out just those songs that are fully contained on one page. For all other songs, I jot down the name of the song and the artist. Then off to the internet I go. Google does a fantastic job finding just the lyrics I need, and I print it off on one piece of paper. As mentioned above, Diane Humphrey also covers most services now, so I can go to church services with my own family. I fill in for her when she is out of town. Diane captions from a mountain town outside of Denver, Colorado called Conifer. She became interested in captioning after hearing about it. Then she read an article about someone who captioned his church service, and she caught the bug. Although she didn't start captioning until a few years after that, she was very much inspired to caption for a church. Diane adds to what Sharon told us. I would add that I am really honored to be captioning for what I think is a very large, well-known congregation. My favorite moments are when scripture is quoted from the Old Testament and I haven't a clue to whom or where the pastors are referring, and I only cross my fingers that the captioning group is understanding most of the message. Remember, sins need to be written in 2 strokes, otherwise you have sins. Also, you have to get that extra S in Jesus, or it's just G's. Diane phones the people in the control room about 20 minutes before the service starts. She explains, I am emailed the sheet music. I used to print it all up, but found myself going through loads of printer ink because it's close to 40 pages, mostly sheet music. I have done what Sharon does and look up the lyrics on Google, and sometimes I open the file, which is in Adobe format, and scroll through and caption the music that way live. Diane was told that this particular service is advertised as closed caption. She sometimes hears the pastor refer to a passage as being displayed on a screen somewhere, which is good, Diane says, because these pastors sometimes read the passages very quickly. And so the captioning continues. All started at his church in Houston by Mark Kislingbury. For almost 11 years, they have not lacked for a captioner, and it's thanks to 3 remarkable captioners, Diane, Sharon, and Mark. Thank you to all 3 of you for sharing your story, which I'm sure will motivate and inspire others to consider providing cart or captioning at a place of worship, perhaps either on site in their home church as Mark did, or remotely like Diane and Sharon. right, now let's get back to a little jury charge. And let's see. This is called land recovery. Ready? Gentlemen, that concludes the testimony in the case and the able oral arguments of the attorneys. I will now charge you as to the law of the case. You have already gathered throughout the course of the trial that Mrs. Martha Tyler is the plaintiff, and whenever the term plaintiff is used, that is the one to whom we are referring. The defendants are the Thompsons, Mr. and Mrs. Thompson. This lawsuit commenced when the plaintiff, Mrs. Tyler, filed a complaint. That is the written pleading that I hold in my hand, and it is not evidence in the case. It is drafted by the attorneys and is a legal pleading. After Mrs. Tyler filed her complaint, she amended it once, as the law authorizes her to do, and that amendment is also a written document that I hold in my hand labeled Amendment to Complaint. The amendment to the complaint had to do with the description of the land that is in controversy. In the complaint, the plaintiff, Mrs. Tyler, sues to recover possession of a tract of land. The amendment to the complaint sets out the description of that tract of land, the possession of which she is suing to recover. She claims, in addition to the possession of land, the sum of $2,500 for the detention of the land. Now that is, in substance, the complaint of Mrs. Tyler. The defendants, Mr. and Mrs. Thompson, come into court through their attorney and file what is called a plea of not guilty. That is the yellow handwritten sheet that I hold in my hand, which is clamped to the complaint and the amended complaint. The plea of not guilty has the effect of stating by the defendants that the matters alleged by the plaintiff in her complaint are untrue. That is, the defendants deny the allegations of the plaintiff's complaint, except that by their plea of not guilty, the defendants, the Thompsons, admit that they are in possession of the disputed tract of land. The legal effect of this plea is that it permits the defendants to introduce evidence of any fact tending to defeat the plaintiff's title and introduce evidence of any fact that would sustain the title of the defendants. In other words, this plea of the general issue, or as it is called, this plea of not guilty, brings within the scope of the case any fact that the defendants can introduce that would defeat the plaintiff's title, and also to introduce any fact that would sustain the defendant's claim of title. Another legal effect of the plea is not guilty is to place the burden of proof upon the plaintiff. In this case, the plaintiff is required to reasonably satisfy you gentlemen from the evidence that she is entitled to a verdict in this case. That is, that she is entitled to recover the possession of the land in this suit, and the plaintiff must prove and rely upon the strength of her own title. The plaintiff cannot recover upon any weakness in the title of the defendants. The burden of proof is upon the plaintiff to reasonably satisfy you from the evidence that she is entitled to a verdict in this case and is entitled to the possession of the disputed land. Now I will charge you, gentlemen, concerning the law of what is called prescription, and I will also charge you concerning the law as to adverse possession. I will give you the law, and you are to take the law as I give it to you, and apply it to what you find the facts in the case to be. You are the sole judge of the facts. You are the one who is to say what has actually happened and what is the truth in the case, what are the facts, and of course you take that from the testimony in the case. Now, a good title to land by prescription is acquired if a person and his predecessors in claim, that is, those under whom he claims, go into possession of land and hold possession continuously, openly, notoriously, and under claim of right without recognition of adverse rights for a period of 20 consecutive years. I charge you that a title by prescription is not dependent upon having a deed to the land or any written instrument, nor is it dependent upon assessing the land for taxes or paying taxes on the land. I charge you that when title by prescription is acquired, it is as good as title as any other title, and I will repeat that. In order to acquire that, is to get a good title by prescription. The thing that must be done is that the person and his predecessors in title must go into possession of the land, and they must hold possession continuously, openly, notoriously, and under a claim of right without recognition of adverse rights for a period of 20 consecutive years. If that is done, then title by prescription is acquired to a piece of land. Now let's get back to some literary practice. Let's see what we have in this one. This is called She Bounced, No One Noticed. Ready? Here we go. The child under 2 years was being carried by her 7-year-old sister. They were quite a team. When elder sister placed the youngster on the floor, the young child did what many young children do. She placed her arms high into the air and raced off in the opposite direction. Then elder sister would pick the younger up. This was repeated multiple times. Up, down, run, up, down, run. Perhaps a parent was deaf. Would this make a difference to others? Perhaps. Perhaps the parent was hearing. Would this make a difference to others? Perhaps not. While working, I saw the entire moment in slow motion and had a different reaction than all others. For starters, I saw the bounce. No one else viewed the incident, which I saw unfold clearly. I stood a few feet from their feet. The small child was walking in wide circles. Her sister looked away for just a few seconds. The parent was leaning on a counter, filling out a form, eyes focused up and away. I stood behind the family, watching the children with a smile. When the child hit the floor, I was the only person who moved to help the child. She hit the hard floor with a loud pop. Her chin bounced backwards, her ponytail whiplashed up. Then it flew to her sweatshirt, which had a large pink angel on the front. I gasped and reached out to her. The child picked her little self up off the hard floor, shook herself truly, and stepped forward. She did not miss a beat once she regained her footing. Her little Cinderella sneakers took off before her arms were balanced, and she wobbled for only a few seconds. I saw the fall. I reacted quickly. When I saw she was quickly back into her good-to-go run-walk after bouncing, my arms were extended forward, palms up to catch her. My posture was frozen as I bent down to help this young child. Her pink sneakers had no dust on them. She was back in full swing, swinging her arms, not the least bit uncomposed, as she moved forward. People saw me in the awkward posture and asked me if I was okay. I nodded and said, "She bounced. No one noticed, perhaps as it should be." The adults and teens near me all laughed. The elder sister did not hear my words. The youngster's parent did not hear my words. Several men and women attending the working event voiced my words, perhaps as it should be. Yes, all my children bounced, that's for sure. The parent never did see the bouncing of this little daughter, who then had only a red mark on her forehead as evidence. I watched the family members depart the area. After work that day, I continued to think about the bounce. I wondered what part of our day have events wherein we bounce and no one notices, perhaps as it should be. When we then have the option to pick ourselves up, dust ourselves off, and move forward similar to this child under 2. Do we take a moment to readjust? Do we wobble? Or do we have a moment with setback? Our answers may vary on the day, the event, and our world as we see it at that moment. Yet the cool part about this bounceability may be the fact that no one will notice when you bounce. When no one appeared to notice the child's bounce, I looked around a full 360 degrees. to see if anyone had seen what I had seen. Trust me, I did. Nope, no one else saw the Olympian bounce, and she was so good with her bounceability. Experienced, in fact. Are we experienced with our bounceability? My question to you is, what happens when you bounce and no one notices? If no one were to notice you when you bounced, would you just dust yourself off and move forward with or without a wobble, or would you evaluate thinking a lot? I'm talking overthinking here about the bounce before moving on. Are we more detached at work when bouncing? Maybe. As court reporters, keepers of the record, we are trained to be detached and to accurately document. Detached when not working? Many of us, not much. Do we take bounce lessons and then learn? Even on a good day, could we? What would we do if we focused on this bounce as an opportunity? Students, cart providers, broadcast captioners, court reporters, and instructors make decisions like this each day. Many of us make the decision to react or not react to a bounce each minute during dictation and work, yet the defining moment might truly be when you notice the possibility of when the actual bounce occurs. The knowing may make all the difference. The child was not at all surprised she bounced, perhaps as it should be, not at all. With the new year, I invite you to view the possibility of having bounces that no one notices, then clearly moving forward with focused attention and focused intent. This new year, I ask you 3 questions. Would it make a difference to you if the parent was deaf or hearing? What would happen if you bounced and no one noticed? Do you have bounceability? You did when you were younger. Yes, you truly did. Perhaps you want to rebuild that skill with joy and ease. Bounceability. All right, that will conclude our literary and jury charge practice.